think it's okay now. Sorry.
Check. Sorry. Can I just check? So I think Gary Clark, this was mentioned. Okay. It's Gary there. Sorry.
Yeah. Okay, so it's got the.
So if I get Mr. Shayler, who's head of the enforcement and safety service, working of Borough Council, so I'll introduce the application. So you have a report in front of you. I've got it numbered page 7. Hopefully the page number is the same. Agenda item 3 entitled application for review premises license. Section 55. So the application is for this subcommittee to consider and determine the application for a review premises license PR 0353 Lagoona Park Waterfront Inchwood Reading RG 303. The application for review is received from Mr. Mike Hardy, the licensing officer of Local Council, 3rd March 2023. So at today's hearing, the licensing authorities representatives are Mr. Hardy, who's sitting next to me, and Mr. Hinchley, who is the licensing services manager. There's also a representation from responsible authority of Thames Valley Police, Mr. Gary Clark. So members of this committee are requested to determine the application review, having regard to the review application, the representations received, and the requirement to promote 4 licensing objectives, which are listed over the page 8, halfway down: prevention of crime and disorder, public safety, prevention of public nuisance, and protection of children and staff, or any reference to the 4 licensing objectives. Back to page 7, towards the bottom under the recommendations, it lists the options which are open to the subcommittee. I don't propose to read them all out. That's the options open to the committee. I'm returning to page 8, about halfway down, to confirm that the premises to which license PR 0353, the license authorises live music, recorded music, performances of dance, other entertainment similar to live or viewing or musical dance performance, facilities for dancing, other entertainment facilities similar to making music, late night refreshments via alcohol. The permitted hours are 10 hours to 500 hours. Premises licence holder is Mrs. Shirley Hank, who has a personal licence. On to page 9, towards the top, full details of the review with the supporting information are set out in the review application which applies to the full. On the 16th of March 2023, Thames Valley Police submitted the representation in support of the review application as part of the representation, which is Appendix C. The licence holder has been invited to make submissions and to respond to them. So that concludes my opening presenting the review. So we have our
Okay. And the next item on the agenda, you have it in paperwork. It's up to us to ask the licensing team for any clarification. What? No, I think it's all okay. Okay. The applicant and the licence holder should have an opportunity to put questions to the licensing team. So that's
The applicant in this instance is Mike Harding. He's the one supposed to be. Yeah.
We don't have any questions at some point, no.
And now I invite the applicant to make any representation.
I
So as the responsible authority for licensing authority, we've submitted an application for the review of the premises license. As the scope of the hearing today gives you a series of options. The series of options include you taking no action at all. You can modify the scope of the license to include different measures, different conditions, timings, and so on and so forth. You can exclude licensable activities. You can also take a suspension of the license as a disciplinary measure for up to 3 months. You may even revoke the license. You have the ability to remove the DPS from the license. So you have a series of strengths that are available from a regulatory capacity. Over the scope of the hearing, it will be within your role to determine what the outcome of this hearing will be. So those are the options that are available to you. You're going to hear from ourselves as a licensing authority. You're also going to hear from Thames Valley Police, who make recommendations in terms of dispensing with this hearing and the reasons for the hearing. So to go into some of the detail, on the 18th of February 2023, Lagoona Park held a boxing event. During this event, an incident of disorders took place. It is alleged that Lagoona Park held an unlicensed boxing event, which on summary conviction is an offence to section 136 of the licence. The scope of the review, it details the 4 licensing objectives. These are the core theme to licensing, and so we've split the application of it into what relates to the objectives, what we would want to see from the applicant in terms of the response to this hearing. The review hearing is the ability to take stock of what's been happening at the premises and to assess where things have gone wrong and to put in measures in here to resolve that. So it's a review where you expect an outcome you expect in this case. So to detail the reasons as to why we're here, the first licensing objective is the prevention of crime and disorder. Police reported an incident of assault at Lagoona Park on the 16th of December 2022. This report describes how the aggrieved was kicked in the head during a Christmas party. The police reported an incident of crime and disorder again on the 18th of February 2023. Now, this incident was described as a fight involving 20 to 30 people, 4 injured parties. The report details that 1 person suffered a severe cut to the face, and this has happened during an alleged unlicensed boxing event. There does not appear to be adequate provision from a prevention of crime and disorder or public safety perspective. In terms of the detail of the circumstances and background here, we have Mr. Andy McLeod Ross, stated on the 25th of November 2022 that the premises has 38 cameras. When CCTV was requested by Thames Valley Police, only 1 5-minute clip from a single camera was provided to them. The DPS, the designated premises supervisor, is responsible for conditions and the overall management of the premises and training. That's Mrs. McLeod Ross. And we did not receive CCTV footage directly to council licensing officers on the requested. Licensing officers have since viewed that CCTV footage by contacting the detective in charge of the case. The footage itself is black and white CCTV. It is limited. The perspective is from a camera situated behind the bar. It starts around 7 o'clock. And it begins with a crowd of people looking at something off screen and it progresses to several fights in the bar area. A police report that states that part of the premises responsible for the 16 security staff. It's not sure whether or not they were stewards or actually SIA licensed. What we see from the footage is that there appears to be a steward format, and then later on the SIA badge store staff arrive post. There's no interaction. There's no steps to diffuse the situation because there's simply not there. The SIA, there's a difference in level between a steward and an SIA. One's licensed, one's not. One's licensed and trained to professional standard, and those licenses can be revoked before. A police report states that part of the premises was the 16 staff that were reported to the working event. However, from what I've described, there is little security presence or intervention observed on that CCTV. From a public safety perspective, the incident on the 18th of February 2023 occurred during this boxing event. There's no authorisation in place under a premises licence or even a temporary event notice for the regulated entertainment of boxing. No risk assessments or other documents were provided to the council in advance of the event. A police report also states that the owner was unable to provide the attendance numbers. Lagoona Park, they do have a licence condition. They have a licence condition stipulating the need to attend safety advisory group meetings. Safety advisory groups are often used for event organisers. It's a voluntary measure, it's not a statutory measure, and it's used to encourage best practice. The voluntary measure makes attended by a number of responsible authorities from a health and safety, environmental health perspective, licensing, police, so on and so forth. So that was not actioned. Move on to the protection of children from harm. There is a licence condition relating to children on the premises. It's just a statement of fact. That's how the condition reads. You can vary licences to change conditions around children. You can mitigate risk. You can put measures in place to allow children to enjoy events. It's possible. But the starting point is the premises licence as a condition about not having children on the premises. It's a slight binary approach to that. It needs to be changed and addressed. Variations can be submitted, and also those measures to protect children from harm can be submitted. There's an ability to have freedom in that respect. The starting perspective is that there's an existing condition. So when council officers visited Lagoona Park on the 25th of November 2022 to inspect the FIFA World Cup fan zone event for England's second game, Lagoona Park has this licence condition that is no one under the age of 18 to attend events. The business owner, Mr. Andy Ross, states that during the visit that no children will be admitted to the event, but later on when officers return, they observe those attending. For the prevention of public nuisance, what we've asked for is adequate conditions for the prevention of public nuisance, that they need to be considered as part of and need to be added to the licence. Appropriate measures for the types of events that Lagoona Park are hosting. We have received a response within a bundle that looks to address some of those measures. Finally, we have concerns over management, which Mr. Harding wants to highlight to you as we conclude the concerns over management.
Ma'am, as the licensing authority responsible officer, I have concerns with the management of Lagoona Park for these reasons. Lagoona Park have allegedly hosted an unlicensed boxing event. There was no notification of plans for the event, and an incident of disorder has occurred. There does not appear to be adequate security provision in place, and the current license conditions are not reflective of the types of events that are being hosted. During an inspection on the 25th of November 2022, Antisocial Behaviour Officer Jaden Sanders and I were sworn at, and we were told we were not welcome and not allowed on site by one of the business owners. And finally, Lagoona Park did not provide council licensing officers with CCTV footage when requested. To clarify, pages 24 and 25 of the agenda list specific incidents, and taking all of this into account, a review is necessary to consider appropriate measures for the promotion of the licensing objectives. But thank you, Chair, that concludes our report.
It's up to us now as a subcommittee to ask questions of the licensing team. More
Yes, I was bothered by the fact that they've seen children present on site, which on the face of it seems a very clear thing that should not have happened. Can you give us any further details on that?
We don't have any evidence of children on site for the boxing event. So if we can separate there has been one inspection at site, which came about because of a police operation, which we were part of. As a licensing authority, we joined Operation Aurora, and as part of that, Mr. Harding was tasked to visit premises which were showing us up. During that inspection, Mr. Harding has used the existing premises license to what conditions are on that license. Now, the license, you'll hear from the representatives here, and it's accepted as review. The license as it exists currently is not fit for purpose. It's not fit for purpose because historically there was different types of events that were happening on the site. They would have sort of student nights and so on, and it's badged up in that way. We have met with the licensees. We've met with them at Shoot End in this very room, funnily enough. The outcome from that meeting was to look at those conditions because they're not appropriate for the types of events. There's a merge. Now, ultimately, that responsibility does sit with the license. It's their license. So when we have one of the responsible authority officers that has a list of conditions, generally the expectation is on an inspection to go through all those conditions, and generally you'll find that there's compliance. And if there's not compliance, there's a steering in terms of shifting to where you get to compliance. It is a stepped approach. We don't necessarily jump to a review hearing instantly. We don't necessarily jump to a prosecution. There needs to be a public interest test to resolve. And it should be the case where we demonstrate stepped approach before doing a review, carrying out a review trigger. We have attempted to do that because there is a recognition in terms of the licence conditions not being fit for purpose. Where there was a FIFA World Cup match, officers have observed that there was children on the premises. There's a licence condition to say there shouldn't be children. There's a ban against approach to it. There is still an ability to run a safe premises with responsible licence holders and have children on premises when there's events on. You can mitigate risk through lost found children policies, DBS checks for staff. You can mitigate risks in terms of the types of events that you're actually hosting. And it's perfectly possible to have a football type event where it's the World Cup and have children at their site. However, it's not what we're seeing in terms of the licence of the condition. We're not seeing any other measures. What we're seeing on that licence is that children should not be at events. If that's to be changed, then the method to change the condition is to apply to vary the licence. Do a minor variation or you can do a full variation. We did meet with the licence holders. We did discuss some of these policies. We did discuss some of the conditions in details. We were all in agreement that the conditions weren't fit with them. And there was homework to go away with the licensees. And the response back to that is to set out how they're going to manage the premises. What we found, which is unfortunate, what we found is that we've not been able to take forward that type of relationship that we would have expected. So we've obviously had an inspection. There's been conflict during that inspection in terms of how one of the officers has been treated, which is never acceptable. And then the outcome to that meeting is a direction to change the licence conditions. What would have been useful at that point perhaps would have been drawing into a lawyer or someone with licensing experience and bringing through an application to change that licence. We didn't quite receive that. We received an application and the application itself didn't contain any detail. There was no detail. It's a step, but we've got to be a little bit serious about this. The application that we received was Mr. Inches knows about this. And whilst I do know about it, it doesn't fulfil what an application needs to look like. As that's moved on, we've then had incidents of disorder at the premises, or we've got continued incidents of disorder. So, from a licensing authority perspective, we were not looking to review that license. We were looking to review the license. Absolutely. We were absolutely looking to review the license. We weren't looking to apply to a subcommittee to review the license. We weren't looking for a formal process. And we had an expectation that things could be resolved through an application, through what was the remediation. Where things have overrun themselves is where we've had instances of disorder and we've had unlicensed activity. And we've got to a point where, as a responsible authority, unfortunately, we were pigeonholed into where we can go. There was only two ways that we can get conditions on a license. That's either by way of a voluntary application, where you consider conditions, or by way of a review. So we were effectively sit between ourselves. We've had these incidents that have gone on, which are serious in the licensing world, and the need to review and address the measures at a point. We have the option to go back to the licensee and say, you need to put in your application, you need to change these things around. And what would have happened is we had a route whereby we could have re-entered those discussions again and talked through what our expectations were, or we had the method for review. Now, ultimately, the method for a review, it starts a timescale. It means it happens, and we can be confident that from the outcome of this process, that we should see issues addressed. And I think we'll see from the response from a lawyer in terms of how they're looking to address these things. So, well, the question about the children, it is concerning. It's tremendously concerning. Well, there's a split instance, there's a journey through this, there's a narrative to this, which needs to come out a little bit more. And you've got to hear from the respondents in terms of the contact that we've had. So it is certainly serious, and it is allegedly a breach of condition for having children at the premises. In terms of the fearful factor of that, there can be mitigation. So it's not necessarily a noose. What is a noose? What is a noose here is the concerns over the management, where we're back in this route, where when we give advice and say we need to look at the conditions, and then we have effectively a frivolous application back, and then we're matched with incidents of disorder, and we're having a large scale fine for an activity that they're not supposed to have. And if they had it, we could have had plans served on us, responses through the purple guidance in terms of adequate security provision, whether it's a white collar boxing match, whether it's a professional boxing match, those types of interactions, all of that, none of that's happened. So there's an issue between the authority as a regulator, which is what we are, and at times we can come across as the bad guys, but our purpose is public safety. So we've got a role, we've got a position to play. But it's those things that are missed, and that's why we're in the review proceedings now. It's not come sort of frivolous from us. It's not come as a knee-jerk reaction. It's come as a need to solve the problem, and that's where we come through. There is a difference in events, and we didn't have any children at the boxing event, so it's a slight difference.
Okay, thank you.
Thank you. Right. Have we got any questions to ask of the licensing team?
I mean, just reading through this license, it's on page 13. In paragraph B. It says the festival is not open to anyone under 18 years old. Technically, sure. I mean, is this license, was this issued for a particular event? And it's been rolled over to apply generally, because I mean on the picture you've given, there's obviously children playing in the water park. I mean, the park's not actually open to
The water park is not a licensable activity. The licensable activities, for a license, the licensable activities are regulated entertainment. Late night refreshment in this hot period being sold after 11 o'clock, or supply of alcohol, or sale of alcohol. They're the scopes. So you walk the water park, there will be duty of care, and there'll be safeguarding measures that will be in place for that. That'll be health and safety. The license itself is just for the sale of alcohol. So it's where the bar is being used, or if the site is being used for events like football, like a student's event, like a function.
weddings. Is that?
Weddings.
Does this weddings without children then?
Do you have weddings inside? Yeah.
But I'm sorry, but it's for the applicant to make their representations, not to ask questions. License holder at this stage.
But I mean, I'm just sort of curious.
So that's where that's a key feature to this. At the moment, there's a condition that's just potentially could be too restricted. But if it's too restricted, then we need to hear measures, and maybe that condition needs to be altered. But at the starting point at the moment is that there is a license condition which is there to protect children from harm. And it does relate to effectively a legacy from how they used to have different types of events at that premises. So you're quite right. You're quite right to look at that condition. We're also jointly of the view that the conditions that are actually on that license not fit for purpose. That is effectively the theme all the way through the contract that we have. The conditions need to be altered. They need to be altered to the premises. The responsibility of that sits with the license holder, which is why when within your bundled response, you've got conditions from license holder. You don't have conditions from the responsible authority. You don't have conditions from the police. And we can ask for conditions on there, but ultimately it's for the license holder to conduct their own risk assessments to assess what they think is appropriate and necessary for the promotion of the license objectives, and then to come forward with a response. Yourselves, decision makers, you're the decision. I'm not decision maker. I'll come to you with evidence. I'll come to you with the perspective of the licensed authority, but certainly not decision maker. So when you hear a response from the applicant, from the respondent, it'll be a discussion over what conditions are applied, whether or not you feel that they're appropriate. And it'll be useful more for the types of questions around protection of children from harm to go to the license holder because of their license. We, as a responsible authority, pointing out that the existing conditions are a breach, which could be quite bureaucratic on the face of it. That's what the condition says. And we're not seeing any other external measures as to why that condition should be enforced.
And I mean, this news conditions. You've been involved in talking with the putting these together. It's a sort of two-way thing with the police as well.
Those conditions have been served on environmental health, pollution control, health and safety, which is public safety aspects. They've also been served on the police, and we serve them ourselves as a licensed authority. We've not made any comment in terms of agreeing any conditions. Ultimately, this is now a review hearing. You yourselves are the decision makers. One of the points here is that if we stepped into a fool's errand is to step into say we want this condition, and for conditions to go on that license, but then there's still to be disorder at the premises, and for a license holder to turn around and say, "Oh, we agreed those conditions with you. What more can we do?" So it's always the balance is always going to be on the license holder. They need to make an assessment themselves in terms of what they feel is appropriate. Yourselves as a decision makers, you're either accepting of that view or you're not accepting of that view. You've got another series of options, which include suspension, revocation, and removal of the DPS. And it would be from the license holder to provide a response if that's satisfactory to yourselves or not. So we won't provide further comment in terms of the conditions that have been put forward. But I think we can all recognise that certainly the conditions that have been put forward are a marked improvement in terms of what's on the licence at the moment.
Jim, could I ask some questions for clarification?
Yes.
Just a quick one that is mainly to refresh my memory, if
Correct, yes.
possible. I think you mentioned the undertaker steps approach. And it's perhaps unusual that such an approach culminates in a review meeting.
Mm-hmm.
Is there anything appropriate you can tell us about that, or that we would need to know?
So the ultimately, we're ultimately forced into the position, and we've had to remove territory. There are other types of reviews that happen, which are summary reviews. A summary review is an expedited review, where there is a serious incident, and that's where there's a stabbing, drugs related. We're not in that territory. We're not in a territory of a summary review. The applications come from the licensed authority representation. It's not an expedited review. Where we've arrived at our position is that we have carried out an inspection. We've noted that the conditions are up pretty much all in the pitch. We've also come to the understanding that the conditions are just simply not relevant to the types of events happening. We've requested for an application to be submitted to change those conditions. We've received an application to vary. That application was not fit for purpose, wasn't a valid application. And then whilst that's happened, we've had the unfortunate incident of an unlicensed boxing event, an allegedly unlicensed boxing event, which has had an incident for 20 odd people. When we viewed the CCTV footage of that, we are certainly not satisfied by security provisions. The difficulty there, as well, is because of the input back in terms of the relationship that we've had so far, is that the expectation would be that we would be served a plan or a risk assessment or an event safety. Well, actually, rather than a risk assessment, we would expect an event safety management plan, which would detail how an event's going to go to be managed. That would be the expectation. We've not had sight of any of that, so we've not had any comments back. We've not been able to have any sort of scrutiny over the events that are being hosted. So that regulatory arm doesn't exist. It disappears. So what we'd like to see is that relationship improve. We would like to see marked improvement in terms of how events are hosted. We would like to see recognition of what the licence conditions are. We would like to see a step towards the mutual respect which we experience with other premises across the borough. And as part of the review, we are bringing it for that attention, because despite it not being knife related or drugs related, the issues are serious, and so it does point us into the review territory. When we decided to submit the application to review, the options are effectively to go back, meet again, and discuss, to then have an application. However conditions are agreed, they're going to end up being agreed in some sort of hearing, whether it's an application from the licence holder or it's a review. And we felt it was appropriate at this point to submit the review application, because it puts it on a 28-day consultation. And knowing that the fact there's going to be some sort of hearing, it made common sense to submit the information to the authority, to yourselves as members, and for you to have this as a decision. There's also an aspect to this which is just good governance. Good governance is, in a way, taking those decisions away from officers. We're not decision makers, we're the elected members. We know our role. And so with that, you should be served with the evidence in terms of what's been happening at premises within your borough for you to be to be able to make decisions on your own borough. So it's a good governance practice to go in that way. Ultimately, there would have to be some sort of application, some sort of hearing to get to where we're standing, and that's why we followed this approach.
Can I ask a question? I'm not sure whether it's of UA or UK about boxing licences.
Yeah.
What's the difference between a boxing licence and a licence for an unseen type social events?
There's different. There's effectively regulated entertainment. There's indoor sporting events. Boxing is a completely separate licence for activity. You can have indoor sporting events. You can have live music, recorded music. And then boxing itself is its own entertaining, it's an entertaining provision. So if we're to issue a license for that, then it needs to feature as an organisation. In the same way as the sale of alcohol is licensed for activity, in the same way as late night refreshment is an activity, there's a separate entity for it. So it doesn't feature as part of this premises license. And because there's not a temporary authorisation, a temporary event notice, or some other type of authorisation in place, it means there's no authorisation. So that's a law. It's not a policy. It's a law.
So you'd expect we went on this, they would license, temporary license for boxing event.
Yeah, you could do that. That could be less than 500 people. So realistically, the license would need to be, if they're planning to host boxing events in the future, that license would need to vary to include boxing events. Because there's likely to be more than 500 people. The temporary event notice is less than 500.
Yes.
Just to explain, mine is rather an unlegal license. So if I'm asking questions of anyone during the course of that, it's purely to assist the panel. Kieran, just one, actually following from the point that's just been made, just to make things a bit clearer. I'm looking at page 15 of the document, which I think is the summary of the premises. And it's got a list of licensed activities. I think you can see it there. So, for example, you'd see boxing on that list, would you?
Yeah.
If that was included. And then a couple of other questions. You mentioned operational order. What is operational? What was it?
Do you want to explain
that? Maybe Gary can mention it later in more detail, but essentially we were contacted by the police saying that they were having an operation for fan zones for the World Cup. And as part of our role as licensing officers, we would go out and just check, make sure everything's running smoothly, checking the license conditions, checking the licenses, essentially just ensuring that it's a safe environment during a time where premises may have more visitors or be hosting special events. And Lagoona Park was flagged to us as one of the big fan zones in the borough, or the only big fan zone.
Just to add some perspective to you, this was an unusual one to place in Clinton. So it was not relevant. It's not how you would picture a fan zone to be. So when we're talking about fan zones, in terms of the terminology of it, we probably need to bring less grandeur to it because it was not relevant because it was in a way. That was still formed part of the operation, of course.
Mentioned there was a meeting with the licence holders about the conditions and the licence in general. Remember the date that meeting?
Sounds about right.
All right. Just so where it fits in the timeline, and so because what we've explained so far, we've got incident on 25th of November, then the meeting on the 2nd of December, and then you've got another before you've got the 16th and 17th of December. Then into boxing, so the 18th of February. So that's where it fits in. So it's after the first incident concern. And one last thing, I know you're reluctant to comment on the conditions of the, but I mean, are they, as the license, as the responsible authority, are they adequate in your view?
There's certainly marked improvement in terms of what's on everyone. We can see that there's a noise management plan included. We can see that there's decibel levels included.
Yeah.
We can see that CCTV is actually a condition. At the moment, the license doesn't even have CCTV as a condition, which is a real barrier. Because when Mr. Harding is asking for CCTV and doesn't get the CCTV, that's off the police, but he doesn't get the CCTV.
Yeah.
And then we go to the license to see if there's the condition to basically use a regulatory role to say you need to provide the CCTV, because if you don't, it's a breach of his license, and to find that absent. So there is marked improvements.
And is there anything in line that you would expect to see in this premises to work properly?
I don't think there's anything that we've stood out. There was some mention in terms of discourse about having IDs cards for types of events. This ultimately depends on what events they're hosting. You know, we need to hear from the applicant in terms of what events that they're putting on, and how they're planning to use this license. And then from hearing from that, that's where the conditions.
And don't put words into your mouth, but it sounds like the line that responsible authority is taking is we're not in a situation where saying this premises license holder can't continue in any shape. Is there a case that if there's sufficient conditions in place, you'd be satisfied with that with the license rather than it being revoked?
I see what you're saying. I'm not sure if that matches the same view from the police, but from the licensing authority, that's certainly what we're looking for in terms of
Thank you. Chair, thank you.
Any more questions, please?
Yeah.
Let's move on to item 9 on the agenda.
May I ask a question for clarification?
Yes, of course.
Thank you. Mr. Hinton, could you just say about those licensing conditions? When did you receive them the first time?
I couldn't tell you the date. We did receive them quite early on during the review process. There has been steps from the solicitor to contact with the police and environment. So it would have been after we submitted the application to review. In terms of the bundle that we've got, we've received that relatively late, just before the hearing was forward. We haven't signed.
So if the application was received on the 3rd of March, it was sometime after that?
Yes.
Do you know what sort of boxing event it was? Was it professional, amateur, participant? Do you know what sort of shot? Yeah. Mr. Harding, if I could just turn to you, first to page 27 of the panel, could you just confirm that's your signature?
Yes, please.
And to the best of your knowledge, the confidence security report with that.
Yes, I am.
If I could just ask you to clarify page 22 in the agenda, paragraph 3, under the heading prevention of crime and disorder. Where it says police report on the incident, can you just let everyone know how you became aware of that?
Certainly. So, on a weekly basis, usually on a Monday, we receive a report from the licensing team at Thames Valley Police, detailing if there have been any incidents or sort or anything like that at the premises of this local borough. And at that point, we became aware of the delivery. In some instances, perhaps if it's been a more serious incident of disorder, we'll also get a report which is called a Gen 40, and that is more detail to an individual incident. So in an individual incident at a specific premises, and there'll be more detail about that. And we receive both of those for the 18th February event.
So just clarify, the December event, it was on the weekly.
Yeah,
The February event, it was on both the weekly.
I believe so, yes.
Moving on to paragraphs 5 and 6.
Chair, sorry to interject, but I'm conscious that I've given some leeway to the licensing authority that's here to present the report to you, not to cross-examine one of the witnesses. I'm conscious this is a very substantial departure from your procedure at paragraph 8. I just want to make that marker known now. So
You can make it known that we are going to carry it.
that's absolutely fine. I just obviously, because of it's a procedural departure, I need to make that.
I just interject that is correct, because as I understand it, we have Kieran, who is the responsible authority, but Ed's representing the licensing authority, which are meant to be two separate.
I'm grateful to your legal advisor, and I think the situation is already perilously close, given that Mr. Hinchcliffe is the actual author of the report. You see his name appears on there, but now appears to represent the applicant in this matter. It is it is close to the wire.
Can I take advice?
You can, of course.
Just what I would suggest, I mean, and I think it's fine, Ed, asking for clarification.
Yes.
But not to leading evidence.
As it's been done. Yeah.
I think as well, to be fair, the statements of the officers are in the bundle. They've got a statement of truth, just like with the premises license material. And I think that's adequate for you taking what's read as being what the officers have put forward. What I would suggest is Ed's got nothing else for clarification as to ask. It's probably right to hand over to the premises license. I just do want to clarification.
I'm taking this into account. Don't wish anybody to. Perhaps I could just ask you to say how long you were on the site when you attended the 25th of November.
We and social behaviour officer Jamie Sanders and I initially visited around 4 p.m. and we were there for about an hour. We then went elsewhere to do other checks, and we returned at I believe 8 o'clock for about 45 minutes. So 2 separate visits for almost 2 hours.
So let's move on to the next thing, where I'm going to invite the applicant to make their
Senior legal advisor leading forward.
I think unfortunately, because the process is more geared towards applications, when we've got a review, if you like, the roles have been reversed to a certain extent. So if you think of Kieran as the applicant, I think where we're at is part 11, and the license holding will have the opportunity to the applicant. Not even separately for yourself. Don't you agree with that?
You were 11, yes, indeed. That is where we're at.
It probably would be fair as well, though it's not in the process, is to, because Mr. Clark's here is also Chancellor's authority, to give him a chance, but probably more important to give Mr. Payne a chance to ask some questions. That's it, Mr. Clark. Just these are questions to Kieran.
I'm very happy to take your advice.
Yeah, that's my suggestion.
Politicians.
Well, yeah, I have the advantage that I do these hearings very regularly indeed. Yes, it's regretful, and I am something of a stickler for the procedure. Of course, there are reasons to depart from procedure, and I have no issue with that at all, but not when there is perhaps a stepping over of the line. I only have a small number of questions to ask. And for either of the two applicant officers, essentially, firstly, could you take me to the part of the license which requires the license holder to provide and meet with the safety advisory group? And I mean the license holder.
License here, license no.
On page 13, if that's helpful, I think that's 12 and 13, the conditions. It goes on to 14, but that's to do with
Under the heading of public safety.
yes.
Public safety C. And you can put that page 13.
Yeah. And that requires the license holder to engage in the safety advisory group.
The wording that we have is that the event organisers entered into an agreement to attend joint SAG meetings.
Yeah. Thank you. You've conceded, I'm sorry, I'm venturing into cross-examination, but I think it's common ground that's conceded that there is no condition about providing CCTV. Can I just ask whether any of the officers were present during the course of the incidents that are reported in the
Nothing wrong.
And finally, it's correct, isn't it, that there has been a meeting online between indeed the two officers and myself to discuss conditions that were proposed since the review application came in.
Yes, that's right.
Yeah, that was mentioned. Thank you. That's all I have.
But would you like to come and sit with us?
Just to say, for this one, this slide is a question if he's got the, if he's got any questions.
What you told them.
Yeah, I mean, to be honest, we have discussed, obviously, the chain of events. This was very dispute. I mean, from my perspective, it was unfortunate I couldn't attend the meeting on the 2nd of December. Given what had happened, I understand the reason behind obviously asking the licenses to return to have a discussion around the conditions that are currently on the license. What concerns me greatly that after that discussion, quality of the application that was submitted with respect to amending the conditions, but probably even more so was the fact that they must have been aware that this boxing event was not covered. And they made no effort to rectify that situation, which they could have done by submitting that temporary event notice and limiting the attendance. Now, boxing events, I'm afraid, are notorious for disorder and for the habits and the drain of resources on that particular night. Meant that we had to pull in officers from Reading for something that basically should be done. Now, the only other point I really want to make is, yes, once the review was was sent to the applicants, we did enter into a conversation around the conditions and what suitable conditions would look like for going forward. Now, I entered those on the understanding that these were going to be submitted by way of a new premise application rather than be applied to a license to allow the management team to continue in place. So I have to stand by what I've asked to consider in my representation. As I say, we as a force, we don't have any confidence that if we just simply apply conditions on the existing license and allow the existing premises license to continue, that they will pay scans to those conditions. The evidence we feel is there, but they've just chosen to take a different course.
Thank you very much. If you want to stay with it, you're very welcome.
Someone's got I suggest the same process. If you're always got questions, then probably Mr. Plain, and I'd suggest because the licensing authority was responsible authority, Chancellor. Just ask one. If there's no question research, just Mr. Clark. Mr. Butts, what you're saying, if I'm correct, is you're saying you've got no confidence in the management. So I think we've seen in the papers Mr. Payne sent some draft conditions. I think they were sent to yourself. I haven't got the copy in front of me. What's your view on those? Taken in isolation, what's your view on those conditions?
The conditions that we have agreed are fine, in my opinion, for the type of premise that is being offered.
Yeah.
Where my concern lies is in the management. Right. Now, I entered into those discussions
an email there. It comes to me, it says, people premise.
Thank you. Can I ask what might appear to be a stupid question? And I'm not even sure it's the right place, but I'm going to ask it anyway. Which of your licensing headings did boxing come under? Dancing?
I think it's fair to say that boxing as a regulated entertainment is a specific thing which needs to be authorised on the licence. It's not authorised on this licence. There are some other anomalies on this licence. For instance, it talks about provision of facilities for entertainment. Well, those are no longer licensable. But boxing does not appear on
And did you know that when you put the boxing?
I'd need to take instructions on that particular point. I think there was probably some confusion from instructions that I've had so far about what could and what couldn't take place. Certainly the position is that there have been no other events that have been held since. I think that's right. And there's no anticipation of holding any such events in the near future.
And there is a better understanding.
Yes, absolutely.
Yeah.
Yes. But at that point, I will step aside from my point of being sitting next to these three to my left, and I will say that point has been made quite forcibly by myself, and that process has been gone through. There's a very clear understanding now, I think it's fair to say, that boxing, if it takes place, does require either a temporary event notice for those, it's 499 people, plus the premises licence temporary event notice holder, or through a premises licence variation. You will see that there is no application before you at the moment to ask for boxing to be put on the licence.
And no intention for the one to be.
Yeah, what I'm suggesting, maybe see if first bed and then maybe.
Yeah.
Well, actually, no, just be sorry.
Well, I can shortcut that process because I have no questions. Thank you very much. I think everything's on the paper.
Okay,
And I think the license.
Okay. And have you any?
Mr. Clark, could you just clarify for the panel that is a level 3 designation? How is that different?
It is a much more qualified.
Qualified in what way?
Around the licensing act and what they can.
Well, Chair, as that question has been asked, perhaps I do have a question, because I am not clear as a licensing lawyer, someone who deals with licensing, what the statutory difference is between a designated premises supervisor and a level 3 designated premises supervisor. My understanding is there is no such differentiation. The only difference is the qualification which is aside to the act. Mr. Clark might perhaps speak to that particular point, but essentially my view of this is to become a designated premises supervisor, you A, need to obtain a personal license, and B, need to be applied for to be the DPS on the license. That's it.
Well, yeah, I mean, that is the process.
Yeah.
I mean, the level 3 is a more intense qualification. You give us some sort of big comfort back to the operation.
So is it a formal qualification, and how do you get it?
That that's not something I've looked at. To me, sorry.
Yes. Shall I say? Essentially, I think what is being referred to here is a essentially EQ level rating. There are different levels. So, for instance, there is a qualification which I think is level 2, which is responsible alcohol retail. Level 3 is a much more advanced qualification. It's not a requirement of law. It is, however, an indication that a person has completed additional training. It's unusual, I would say, to see that qualification appearing on the license condition. It's for a licence holder to decide what training they want to put their staff through to make sure that they exercise due diligence and can then defend against any such proceedings. But essentially, it is a qualification. I think it's a 2-day course that has to be sat. It can be obtained through various organisations, search training organisations, including the British Institute of Innkeep, I believe, are doing it. But there are otherwise a number of courses out there that someone can complete.
Okay, thank you. Good to have a bit of additional information.
Yes, it is.
Right. Now going to the next one. Oh, sorry.
So just to confirm the view for terms of rates, in terms of the representation, what you're looking for is the view in terms of rates is to remove the designated supervisor. Okay, great. And to replace the designated supervisor with someone with a same qualification for level 3. That's what that's proposed. Okay. So just to start it out, are the reasons, what are the reasons why these are taken up? So we've asked for the DPS to be removed and a DPS to be replaced with a level. What's the reasons that you're asking?
As I said, that's really sort of what's been contained, discussed. This, fortunately, the current management have displayed a knack, shall we say, or of not adhering to what expected here. So we've discussed the fact that some of these conditions are on this license are not appropriate for the premise. A bit uncertain as to how some of these go on, but with that aside, they still haven't adhered to some of the basic conditions of the license. Way obviously treated polycare councils, the inspections, acceptable. So as I said, the biggest thing to me is to have that meeting on the 2nd of December. Watching events don't get planned overnight. Just want to believe more not realise this was an issue with respect to the fact that it's unlicensed. Obviously, they're not to know that there's going to be a serious disorder there. We've held these events before. Dates or anything like that. So again, so that very fact alone doesn't seem like
So, Mr. Clark, the bottom of page 33, in your representation, it says Thames Valley Police have since been told that this is not the first time the venue has hosted boxing. Do you know if that is unlicensed?
Well, as has been known, licensed activity for boxing, then obviously any previous event that they would have been licensed as well. There is no record of a temporary event notice or systems to be together, but that should have been sourced. Now that information came to me. Said that officers have told him that it's not just on.
Just got one question. It's sort of throws it open a little bit to everyone because it's just I'm trying to find the procedures. Their parents is probably more expert than me. About the process of the designated supervisor. I'll go to Mr. Clark first. Obviously, the review panel has the ability to remove the DPS, which then means the premises license holder has to propose a new DPS. I'm trying to find off the back of my head, there is a process, where the responsible authorities can like veto it, but bring that the new DPS if you're not happy with him or her, they issue back in front of them. That's correct. Isn't it? Just looking at hearing that yours. Mr. Payne, any Is that correct?
No, indeed, and it might not surprise you that I represented applicants where a DPS has been refused. And the test that has to be applied is a very difficult one to pass because the police need to show that there will be an undermining of the licensing objectives if that person is appointed. The guidance is quite helpful in terms of explaining some examples about what would be an unsuitable DPS. And I will just think of one from the top of my head. If there is a premises that has an association with drug use, and I make it quite clear, this is not one of those such premises. There's no allegations about, cited purely as an example. If there is a premises that has a history of drug use and abuse, it would perhaps be wrong to put in a DPS who in the past has had a conviction for drug dealing. That's the sort of example that I give you. It's not about does this person have advanced qualifications. It's about would appointing this person completely destroy the licensing objectives. In my respectful submission, that's not what we've got here. That is not the test that could be applied and followed in this instance. But those are the circumstances, and it is only the police that can object to a new DPS. It has to be exceptional circumstances. That's the one question.
The reason I was asking that is because the police issue is they're saying we want level 3.
Yes.
Yes. Would that give them the opportunity to say, actually, this new person doesn't have level 3?
No, it would not be possible to object to a DPS because they haven't got level 3. It would have to be, as I said, an exceptional circumstance where the licensing objectives were undermined.
Yes. Just thinking ahead, if the panel were those conditions saying any new DPS has to be level 3, what would your response be to that?
I'd need to take instructions on that, but my view in principle that a designated premises supervisor, just apply to the future, must complete within a period of time, a reasonable period of time, level 3 training, as long as that specific course, because you appreciate there are lots of level 3s depending on the types of premises to cover. Because you do a level 3 in food handling, for instance, that would be not the sort of thing. You'd have to be very specific as to what the course would be, but it would be possible to have a condition that the DPS must within, say, 1 year or 6 months complete a level 3 training in whatever it is. The difficulty you have is Mr. Clark can't advise you on what this would be.
Okay, but I'll just stop there. Why Mr. Clark?
Well, he was asked the question about how do you get a qualification, he couldn't answer it.
Sorry.
No, sorry, you have to have people. Okay, I understand now. I think that we're on item 12, where I'm inviting the licence holder for legendary representation.
Yes, could I just clarify, because I know Mr. Clark is itching to get out of his seat. I'm just wanting to make sure that he is satisfied that he has effectively addressed point 15 on the agenda about making a representation. I think that's effectively what we've done. So we've kind of moved around the agenda a little, but as I say, I have no issue with that. It's perfectly legitimate. It's something I would have suggested anyway. Obviously, Mr. Clark said something that I need to respond to. So I'm entirely happy for him to move. Yeah, for us to move on to 12 and say that 15 has already been dealt with.
Okay, then I assume 12 is you.
That is more or less me, although it might be a little bit of contribution from my left. I'll ask those to my left to introduce themselves, because we haven't done introductions as such yet. So as you've appreciated, my name is here. My name is Mr. Penn. I'm representing the licence holder. And if I go to my left.
I'm Shelley McLeod-Ross. I'm the DPS. Kate Brooks, event manager.
Just supporting. Witness. I'm not nice.
Indeed. Let me find happy to go with first names. I wonder, Shirley, could you just explain a little bit about the premises? I know you prepared something.
I've prepared something.
To the committee.
Okay, Lagoona Park is
located just off junction 11 of the M4 on the outskirts of Reading. We've been a water sports centre for over 30 years and now provide non-motorised water sports and hospitality. Due to COVID-19 and the ongoing credit crisis, this has had a devastating effect on our seasonal business. We have worked hard to provide a safe and fun environment for the local community for both day and evening events. We feel that we are an asset to the county as our location is free to enter, free to park, free to use the beach and the swimming area, and we are all a well-needed slice of urban paradise to escape to from the stressful world that we currently live in. Thank you.
Thank you. Okay. Committee, I think the starting point really is to look at the licence that is in force at the moment. And I know Councillor Neil picked out a very important point about what this licence is and what's it intended for. So could I just ask you to go to page 12 onwards within the bundle? Perhaps I can address some of those points. You'll see at the bottom of page 12, there's a reference to Annex 2, which is conditions consistent with the operating schedule. And I don't need to tell you that what's happened here is that an application has been made for a licence. These are the words that have appeared on the operating schedule with that application. And whoever has processed it has essentially lifted those words and put them onto the licence. In some respects, there are occasions where there is no problem with that. But in other occasions, such as this, there are very fundamental problems with the way that that process is being carried out. I'm not levelling any criticism, just to be clear, at the officers who are present here today. This is something which is historic. There is a case, the Crown and Bristol, where it's made quite clear as to what a licensing authority is supposed to do. It's supposed to look at the operating schedule, and the word is translate what is offered in those operating schedules into enforceable conditions. And the guidance sets out some very helpful principles of 1.16, which you might want to look in due course in your deliberations, about what conditions should be, how should they be tailored. And some of the examples that they must be concise, they must be enforceable, they must be clear. Everybody must know essentially where they stand with this licence condition. Unfortunately, that's not what's happened. The background to this, to deal with Councillor Neil's point, is that this set of licence conditions result from an application in 2017, I believe it was, where there was an event, and you'll see there's reference to a festival, page 13 at E, at E, which talks about the festival is not open to anyone under 18 years of age. Now, the intention at that time was that this is something that is different to the normal running process. And you'll appreciate there are two parts to it. There's the hospitality part and there's the water sports part. And a festival was to be held. So an application was made and conditions were offered. And you can see, because they're on the licence now, they were agreed with the licensing officer at the time and put, at least there were no objections from anybody else. And so they were put on the licence. The intention at that time was that those conditions should be temporary, and you can understand why, for the period of that festival. Regrettably, the person that's not to my left that made the application, I think it was the event organiser, made the application on behalf of, didn't include those important words. We only wish these conditions to apply for the event to be held on X, Y, Z. And when you read these conditions through, you will see exactly the point. This is for the event, the condition on children. The festival is not open to anyone under 18 years old. And that's repeated in a different way at the top of the page with 4. No children will only be on site during the event. I'm correct if anybody can explain that condition to me. No children will only be on site during the event. That makes no sense whatsoever. What should have been done is that the conditions should have been translated. Let me give you a prime example, starting in the very beginning. this is a license issued by the local authority. So when we use the word we, we're referring to the local authority. We have appointed a registered security firm, nice of the local authority to do that, who will be wearing high visibility vests. I think I need to go no further than that to point out that this license is worthless in terms of conditions. Conditions that are on here relate to the event organizer. I made that point in the question that I asked, not to the license holder. There is no condition about CCTV. There is no requirement for Shirley or anybody else in the management team to attend the safety advisory group. Now, these are all very eminently sensible ideas, but they are not requirements. And for the suggestion to be made that there is a breach of these license conditions in some way, well, I would be leading the for the charge to defend any prosecution that was taken in relation to enforcing these conditions, because they are not enforceable. They just simply don't comply with the Secretary of State's guidance and indeed the law. So what have we tried to do about this? Well, you can see what we've tried to do by suggesting a more sensible set of conditions, and you can see those towards the back. You'll see that on the 28th of March, and this is following a conversation that I had very helpfully with the two licensing officers. It's on page number on my. That's very strange. There's a letter on my sheet. It's 1, 2, 3, 4 pages back. You'll see it. It looks like this.
I think it might have been the bottom. I've got your letter.
You may have a separate bundle with my papers in.
Yes, it's in the second bubble.
33.
Yes. Yeah. We're looking for a letter like this. Yes.
Yeah.
Very good. And that was a letter that was sent to the licensing authority to us. So we haven't had a positive response either one way or the other, saying no, nothing was agreed. That arose from a meeting that you've already heard took place online between myself and your two officers. As I say, I'm exceptionally grateful that they were willing to have that meeting and discuss and actually to move forward. And during that meeting, we discussed the conditions that appear, I think 2 pages on from that, which talk about the Lagoona Park proposed conditions. And the only point, and one point that was raised during that course of that meeting was the question of ID scanners. That was the only thing that was raised as, well, you might have missed this and wouldn't it be nice to see it? And you've heard pretty much the same thing here, that whilst the licensing authority doesn't want to agree conditions and be seen to be rubber stamping them, unfortunately it has some responsibility to do that. It has agreed, I would say, to the proposals that have been put forward. And you will see that, again, very helpfully, Mr. Clark, who I've dealt with on a number of occasions, entered into negotiation and discussion. I'm grateful for him to do that as well. And you'll see my initial email to him at the bottom of the previous page before the conditions. If you're in agreement, would you confirm, please? We anticipate these conditions will go forward to the new licence application, deal with that at the moment, as well as, for consistency, be proposed to settle the current review. That's the context in which the proposal was made. Now, you've heard that an application was made for a new premises licence. I think it was in January, was the draft application that was put forward. And it was a draft application, and my instructions was put forward to the licensing authority for initial comment. To suggest it was a frivolous application is not true, and I think it's perhaps slightly disingenuous. This was an application to the licensing authority for comment so that a set of conditions could be fashioned, and we shouldn't end up here. The conditions that I've put in the pack towards the end, again, have been sent to the environmental health team of the local authority. You'll see that they've made a comment on the application. It's rather regrettable. Again, I make no pretense. I'm sure they are busy, that we have tried to contact them now, I think 3 or 4 times, to push matters forward, but we've had no response on the proposals. That gives us some difficulty, because you'll see towards the very end of the conditions, there's a reference to 65 dB LAEQ 15-minute a noise level, effectively, at a particular location. We'd hope to be able to get some sort of response from Environment to agree where that would be. In the past, there has been a condition imposed. I think we are no further forward, no further backward. I don't know what to say about it, other than perhaps where those asterisks are, that should read within the nearest residential property. I think those are the only words that I can offer, because of course what we're trying to do is prevent any noise issues in somebody's house. But the reality is we've not had complaints. This isn't an issue that has caused any problems. And indeed, I think it's slightly disingenuous to say that the character of the management is such that they won't comply, because there have been noise conditions in place in the past. Indeed, for the festival event, there's no suggestion that those were breached. There was clearly compliance that took. Now, I'm conscious that there have been some suggestions that there have been incidents of this. And in some respects, it's a licensed premises. Incidents will, to a certain extent, flow from that. However, the point is not whether they occur, it's about how often they occur, because it has to do with the management of the business, and also, most importantly, how they are responded to. Well, how they are responded to in this instance is contained within all the statements that you've seen. You will see from reading the statements, and I don't propose to go through them really to save you time and to save me time, and everybody's time, but you can read what's there. You will see that the security teams that were present on site dealt with the incidents very quickly, and indeed very quickly and before the police presence arrived. And when the police presence did arrive, in some instances, what happened was the police looked around the corner and said, "Oh, everything's under control. Thank you very much. Have a good evening. Bye." That's the reality of what's happened here, because the premises have control. And it is, again, wrong to suggest that there was not enough security on the basis of a couple of clips of CCTV footage. Hence my question to the officers about whether they were present to see how many security staff were there. I think on one night there were 16 on duty on the premises. Quite clearly, the effort is being put in to make sure that the premises comply with the conditions such as they are, as are enforceable, but more importantly, that they promote the licensing objectives. The other thing that the license holder has done is to look at the training that's being provided to staff. Now, I'm conscious that there has been, there has been some suggestion that there's a lack of knowledge, lack of ability, lack of awareness to do licensing. So that has been addressed, and you will see within your pack that there are, for example, a number of training courses that have been completed, and specifically the SWRCOTS, as it's called, training package. I'll find certificates because they're in here. I just realised why my page is unnumbered. Second part tops. So you'll see, for example, those certificates that have been produced. SWRCOTS, if you're not aware of it, is Trading Standards Southwest. It's a group of trading standards officers, or responsible authorities, I should say, that have got together to prepare an online training course. If there is one course that has some value, one might argue it's one that's prepared by the very authority that's enforcing. You will see that those have been passed. This particular one that I'm holding up has got an overall grade of 96.67%. That, I would suggest, shows that there actually is awareness. of what the law requires. Sorry, would you just excuse me? So I think there is little more that I can add in terms of responding to the particular instance. You've heard that there was this one occasion of boxing. That is it. That there weren't multiples, and the suggestion that I spoke to somebody who spoke to somebody who spoke to somebody else, that there were boxing arrangements, a bit like a dance with a girl who danced with a man who danced with the Prince of Wales, or girl who danced with the Prince of Wales, as the case may be. It is nothing more than that. It is supposition and guesswork based on very clearly hearsay evidence, which, whilst admissible, has no weight in my submission to the proceedings today. The fact that the license holder has instructed me to appear before you today and to enter into the negotiations and prepare what has been recognised as the way forward, a set of conditions, speaks volumes. What should also speak volumes is that there are instructions with my firm to apply for a new premises licence as well, to deal with just the bar issues rather than the whole site, as this particular licence does. And then, assuming that that licence is granted, a decision can be made as to whether this licence should continue. It is in some ways correct that it is for the licence holder to vote. But it is also available to you to completely start the slate clean with this particular licence, I should say, and substitute the conditions that we have volunteered in place of all of those that appear already. That indeed is the way that we suggest that this review should go. I'm conscious that we've perhaps run around the houses a few times to get to this point. It's disappointing we couldn't get to that earlier, but that seems to be the position. And so in submitting to you, that is the evidence that we want to provide. I think unless those to the left of me want to say anything else in particular.
The reason for the festival that happened was it was over 1,000 people. That's why we did it.
Yeah.
It was agreed thereafter that every event we had, we would just put it under 500 people.
Yes.
Ever since then, we've done including the boxing event. It was under 500 people.
Yes, and I think that's quite important. You know, this is not a big venue that has thousands. This is relatively low numbers. And the point with the licence is that it's expected to go back to the conditions that were there before. I don't know if those were. I know that this licence, this site, has had something of a checkered history with at least two different licensing authorities trying to issue licences for it in the past.
We sit in two boroughs.
It's been slightly confusing, but the licensable part area. So this is a relatively small premises. It is something that doesn't do events every day of the week. It is a situation where there's a hospitality offering in accompaniment with sports activity. There are occasional events that take place. I think there are only two that you have planned, is that right? Going forward at the moment. So it is a very low-key type arrangement. I think that the only other point that has been echoed is the apology has been spoken to, purely born out of frustration. I think there was a lot of stress at the time, so an apology for that. The licence can only work if there's a partnership arrangement and there's a two-way street with this. I'm conscious that everybody's got to work together to make sure that the licensing objectives are promoted. And I would suggest that the history of this site is such that it's not somewhere that you see on the reports every week. It is something where there have been one or two little incidents that have been effectively dealt with. But the aim is unified about making sure that children are protected, that the public is safe, that there is no public nuisance. Those are the which licensing objective I forgot. But those are the promotional and licensing objectives that everybody is focused on. And by imposing the conditions that we wanted, that achieves the objective.
Okay, thank you. Do we have any questions? Yeah.
I just wanted to hear about the plans for the venue. We've heard about another application being
Sorry,
submitted.
I'm aware that the microphones aren't going to pick up from there, so you might want to come and speak.
I just wanted to hear about the plans for the premises. We've heard a little touch to submitting a new application. So I wanted to have a little bit of clarity on that. And also just to have a bit of expansion in terms of what this premises is going to be used, and how the conditions that have been proposed, how they correspond. So we know about the very historic events where we've had license conditions issued to the license. We've also heard about some of the events that happen at the premises. But we've also heard that during this hearing, boxing is not going to be continued as a license. So we just wanted to hear about what are the plans for the premises and how does that correlate to the conditions that are being proposed?
It's very simple. With the exception of the boxing, things will continue as they have done successfully for many years. This is not a venue that has any ambitions or instructions to change into a nightclub or a pub. It is an ancillary use to do with the water sports activity, which is available occasionally for hire, as one would expect. As with many businesses, this business has been hit hard by the COVID situation, and so it is important that there are some occasions where they can host events to maximise on them. But those events will take the same form as has happened with the being controlled, operating successfully, and I wouldn't like to guess how many events that have happened over the last, let's say, 5 years, but a significant number.
Yeah, 65 last year,
Yeah.
But they've all been over under 100, 500 people.
Yeah.
So for the sake of me, who doesn't know the site, can you tell me what sort of events they are? Like birthday parties, discos?
Birthdays, corporate events, baby showers, christenings, wedding receptions, anything you want really.
It's all that,
Yeah.
isn't it?
Yeah.
Mainly birthdays.
It's something you do in a village hall, but we're a bit better, that's all. Just so you've got a leg to the game, it's a nicer atmosphere.
Beach vibe.
I hope that
Beach vibe.
I hope that assists in terms of. It's unfortunate that you've not perhaps been to the venue.
We've seen the pictures.
You've seen the pictures. I had hoped that the pictures we put at the beginning of the pack would give you a bit of a flavour about what this is. It is a family venue.
I've got one. So we see in the license holders, the bundle, that there's some certificates completed by staff. I was just wondering, have the management undertaken?
Yes, is a simple answer. And to take this further, there is more training that is planned. Just simply hasn't been possible to organise that so far. Sure that the licence holder would probably want to seek some further advice and assistance. I'm not necessarily trying to push my services forward because I'm quite busy enough as it is, actually. But I'm more than happy to advise the licence holder on the quite technical things that everybody is falling foul of, both from the licensing, which is perspective, and the licence holder's perspective, to make sure that the straight and narrow is trod going forward.
Katie, that would include you as well. Is there training for your job as well?
Yeah,
And you've
You've
undertaken
done
it?
it.
Sorry, I really don't
Alright.
know.
yeah.
Yeah, can I just ask a couple of questions? Purely just for clarification, is you're proposing conditions?
Yes.
So are you proposing in replace of annexes 2 and 3 in the license? So you're saying it's to take annex 2 and 3 out?
Exactly so. Exactly so. All of those conditions in Annex 2 that were put in, Annex 3 that were put in to make this a more cohesive and clear set of conditions. And you can see that the way that I've put this is not in the we shall do this. I've tried to help as best I can by putting very direct and clear conditions in to replace the mush, is the technical term perhaps, that's there at the moment.
One question is about the fact you mentioned the boxing.
Yes.
Who was it who looked?
Me. Ricky, what do you want to know? Ricky O'Brien.
This is Ricky.
Ricky's gym. So I obviously organised it with him.
Yeah.
And he booked it with
It's a
me.
charity.
He came to us as a venue and said, "Can we host boxing?" And I said, "Yes."
I'd just ask, doesn't share the use to were you present?
No. Yes, I was, yes.
You was.
In the office.
And sorry, did you realise that was an unlicensed event?
Yes, I did.
Did. And the other thing is you mentioned security staff. Where would the security staff?
Sounds security. Sounds security.
I'm sorry, I said.
They are registered.
It is.
Saving of the event, SIA.
Yeah.
Yes,
I think there was 12 SIA and 4 stewards. I think definitely 10 or 12 CIA.
Very much right.
Can I come back to you in a minute?
Yeah.
Yeah.
Let me just say, so I think the proposal is to clear some of the conditions of the existing business and replace it with the conditions that have been proposed. And one of them does touch on the protection of children. We've obviously got a condition just relating to our children. Also heard in terms of what types of activities planned for the site. So I think I've heard about functions, regulations, and so on and so forth. So what's being asked of you by the license holder is actually to remove the protections children from harm. So I think there needs to be a question going back in terms of how that risk is being mitigated. If it's being mitigated by the types of events that are now being hosted, or just like to hear them to remove conditions.
And I'd like to add a bit to that, Kieran, because if you're having birthday parties and family issues, then surely you're going to have children there. And so we need to be able to know that those children are going to be safe.
Do you want to deal with group of age? No, we have to consider. I think one of the points that we would put forward is that the surplus training specifically does address the question of actual group of age and making sure that, for instance, restricted goods account sold to them. Clearly, there is an overriding duty in relation to the Health and Safety of Work Act as well, which applies to businesses. And the provisions of that act are very general. But be aware that there is, of course, a prohibition in principle to imposing conditions which replicate other statutory provisions. And what we would say is that those issues about protection are dealt with through other legislation. Quite clearly, there are some things to do with the licensing aspect, and that's what we're talking about here, is what is it that's licensable with regards to this, and that's the same with alcohol. That has been dealt with through the training that's been provided, through the surplus and the pounds that it's called training package that everybody who is serving is aware of that. And the other issues, as I say, are dealt with.
Back to the table.
You can stand it, right?
I was just making a few notes when John's things. That's all the clarity. The conditions
That's why I'm conscious we're asking questions.
answer the questions. Yeah. I'm just trying to confirm that the conditions that are put on the license by the event organizers, that would the same. 2017.
Yes, when the current license takes its current form, because an application was put in 2017 by the event organizer on behalf of the license holder for this particular event.
That was 2017.
I believe so.
Mentioned about staff training, we've got certificates. I mean, I'm thought it would be normal practice for the DPS to look at the conditions on the license in order to ascertain what training is required. Would you not agree with that?
Well, no, let's be clear on what a designated premises supervisor is. The Act is not very helpful in describing what a designated premises supervisor is, other than saying it is a person, holds a personal license, who is designated for the premises. That's pretty much it. There are no specific requirements for the DPS, I would suggest, in the legislation, but it is made to be a construct that the DPS is responsible for. That's not true of the license holder, person undertaking the license. Is it right that the license holder should look at conditions from time to time and see whether they're suitable? Perhaps that is so, but there is no requirement to do so. And quite clearly, as a business with so many other things to deal with, tax and child protection and company's house records, there is a limit to how often certain things get reviewed. It is regrettable that we are in this situation, but there was no duty on the licence holder to look at the conditions and make sure that they are satisfactory. It was assumed, as you've already heard, the licence would go back to what it was before. Unfortunately, that's not happened.
I'm sure was a yes or no. You don't think that
there is no duty on the DPS to review the licence conditions from time to time. That is a joint duty between the licence holder and all the responsible persons.
I'm just looking at the conditions that have been proposed. Not sure if I'm missing. Is there, we talk about instant log, CCTV, or supervision policies, which age verification is one. And we also go into the public nuisance. We've covered about the protection of children from harm in terms of the response to that. What also looks to be absent is just this feature around staff training. So the question going back is what proposals are in place for this staff training. The question is off the back of the concerns that is raised from licensing officer, from the licensing authority, and also what was heard from council and police. So we're quite keen in terms of understanding what training is going to be in place and also how that's going to be managed. With the expectation certainly would be the DPS or an external company to manage some sort of training. I don't think we're seeing it within the proposed conditions at the moment.
Well, let me deal with that and take you to the first paragraph. I'm disappointed that that point has even been raised. All staff will be provided with training in relation to the licensing objectives that are commensurate with their duties. So if they're dealing with sale of alcohol, they need to know about age verification, for example. However, the cleaner doesn't need to know about that. This will include the individual's responsibilities, age verification, licensing offences as appropriate. Details of the training will be recorded in a personnel file or logbook and will be refreshed at regular intervals. This is a condition that has appeared on more licences than I care to mention that we've applied. Disappointed that point is even being raised at this stage of the question.
It's most helpful. Thank you. I can see there's not a heading on the top there, the stage training, so that's been established.
It's just a few tweaks to clarify it.
Well, a heading perhaps. But this is a document that is put in this format for the licensing authority to take the word. The headings are meaningless. Have to group together. It's for licensing authority to decide.
Okay, have we any further
There
questions?
was one other point I just wanted to reiterate. Jill, that she boxing event. Unlicensed. She was aware that it was unlicensed. And that she
So the question was,
confirmed that is the
well,
case.
you've heard the evidence already in relation to that. You've also heard that it's regarded as a mistake if it won't happen again. Whether it was held or not is, we would suggest, irrelevant in these proceedings because there are different sanctions available for it. That's appropriate. This is not about finding sanctions to put in place for issues of licence positions, as well as sanctions or suggest there is some ability, but it's about deterrent. That's the point. And the point of this review is, as you've heard, I think full agreement that it's about getting a licence that is fit for purpose.
I agree with what you said. If you do something that you know is not right,
Yes.
you need to be able to explain that.
Yes, and that's why that there are provisions within the Act to deal with that, which are different to the proceedings there. And I would encourage you to see that as a separate issue. If there's anything to do with today, it's about making sure that there is a deterrent in place to make sure it doesn't happen again. You've already heard from me that that deterrent has been explained. And the licence holder will not be doing that type of event again. They've learned the lesson. The deterrent has been met. And in fact, bringing these proceedings today has not been cheap for the licence holder. There has been effectively a financial penalty. I wish I could do this for free, but I can't. And so they have had to pay for that as well. The deterrent factor has been.
Yeah, thank you. One last question, Mr. Ronson. Just looking at the papers, the premises license holder is Lagoona Park Water Sports.
Yes.
Who are the directors?
That's a good question.
I'm sorry, I couldn't hear that.
Shirley myself.
Andrew, were you aware?
I don't really get involved with the licence. I deal with water. So I do all the training on the
So,
water.
were you aware of the?
I was there. Yeah.
You were there.
But I think the question is, were you aware that needed a licence?
Yeah.
No, I wouldn't know at all. I deal with the water and I do the training on the water. So that's why Shirley does this. We're only a
Okay.
family business. Sorry, we're only small family business. So, we're trying to split our resources to make as much as we can through the can.
Okay, I understand now that we're on 16. And we've all done our questioning and are there any points of clarification? The applicants and licence holders shall have the opportunity to put questions to those who've made representation.
I think we've dealt with 16 and
Yes, I just
17.
want to make sure you're happy.
Yes, I'm happy to proceed on to 18.
Yeah, okay. The opportunity should be given to all parties to sum up their case, but not add any new facts. Who's going to do the summing?
So I think we'll go first for the summary. In terms of summary, we've brought the review because there has been a non-licensed auction event, which is allegedly a breach of license condition. And the outcome is for the review is because we've misplaced on a step approach to achieving conditions for a license. We've heard from the applicant serious conditions and proposals, to which there appears to be some level of satisfaction to Thames Valley Police for those conditions. Licensing authority has withdrawn to comment fully on the conditions, which is we are taking. However, there still maintains to be concerns in terms of the management of the premises. And we're very much wanting to see some sort of satisfaction in terms of the continued management for this premises. What's been proposed is the removal of a designated premises supervisor and the replacement with a high-level qualification for that incoming designated premises supervisor. That's been proposed by the police. Licensing authority, we're looking to agree conditions. Well, not agree conditions. We're looking to have conditions put on the license to satisfy yourselves, so that the premises can continue operating. We're not looking to revoke the license. We need to be satisfied that the management of that premises, whether or not it's the DPS being removed and someone being brought in, or whether it's training for existing staff, we need to be satisfied that the premises is going to be compliant with the conditions that potentially being adopted and proposed, and also that the two-way discourse to be maintained. That's what we want to achieve from the. Thank you.
No, Kieran's colours.
Members, this is a matter that it is regrettable that we are at this stage. It is regrettable because efforts were made to start off with in terms of trying to draft the licence application, which would have made all the takers and then had they gone through to conclusion, I'm sure that we would not be here. But for whatever reasons, the process has stood. The applicant was told that the draft application is not required. There was no advice given, as I understand it, about what needed to be done to improve that. The licence holder then instructed others, myself and my firm, to represent them and put together a set of licence conditions. That was done, and in the process between the refusal of conditions being ready, the application for review submitted. So we are here purely because of a matter of timing, I suggest. The timing, however, is important, and in some respects I can understand that the local authority wanted to push matters on slightly quicker than even though the application, the draft form had been submitted. And so in that respect, there's no criticism of wanting to see progress, but it could have been achieved. The licence holder is more than happy to work to promote the licensing objectives, otherwise they wouldn't have promoted these conditions that have been suggested. They would have just said, prove that we breached, and that's it. And that's not the approach that's been taken. It's been a proactive. And there has been a satisfactory, I would say, approach to the licensing part as well. Because you see that this application back in 2017 was made because it was recognised that the licence that was held before was not suitable for our festivals. And so the application was put in and the conditions were modified. So it's wrong to suggest that there should not be any. 75, I think it was said, events happened last year. And in terms of the number of incidents, we are dealing with a small handful. And frankly, the evidence, because this comes down to a matter of evidence before you, is somewhat sparse. A lot of it is based on he said, she said, this happened and that happened. It's second-hand analysis that there was not a designated supervisor, or sorry, not supervisors in place at the premises, when clearly the evidence you've heard that they weren't shown on the CCTV. But that's as may be. There was no breach of the licence conditions. I make that very clear. And so because there was no breach, and because these premises have operated very satisfactorily, I would suggest, barring a small number of instances, this is not a way to deal with a premises that is broadly compliant. We will see that in the pack there is reference to food hygiene. Now, it may be that you were wondering why on earth has food hygiene been put into a pack to do with licensing? Well, it's to deal with that particular point about compliance and can there be confidence in management? Well, food safety teams seem to think so. The presumed approach from food safety is that yes, this is a business that is broadly compliant and can go forward being compliant with the law. It's not a case of the license holder stupid authority, absolutely not. The incident that happened with disagreement, if I can put it as mildly as that, was born out of frustration. But the reality is that this is a premises that has been broadly compliant with the law and has shown that it can promote the licensing objectives. This isn't one where you have reams, as you see with some licensed premises, I'm sure, reams of incidents week after week. You've seen it, I'm sure. I've seen it, 10 incidents in a week. That's not what we have here. We have 1 or 2 incidents a year. That is not really indicative of something, but is badly managed. That's something that's... So what we suggest to you is that actually, in terms of removing the designated premises supervisor, that achieves nothing. Does achieve something is to make sure that all staff are given training commensurate with their duties, to make sure they have got the skills, abilities and knowledge to deal with the issues that they face in relation to licensing. That is number one on the conditions, and that's put there for very good reason, because everything stems from the training. If people are dealing with licensed premises, you've got the training, you've got the knowledge, that answers a great deal of issues. I dare give you the comparison of you, I'm sure, as members of the committee have completed licensing training, and I'm sure that you would not have wanted to step into the sphere of licensing without having had some of that training in the first instance. We've already talked about designated premises, how you get to be a designated premises. And so training is fundamental. I mean, put that dead centre at the very beginning, and you can see that the licence holder has not just spoken about that, but money where their mouth is, and has carried on and has got certificates and done additional training as well to make sure that actually they are on the board. They are moving forward. So that's why we say the only step that should be taken is the one that's agreed from the licence holder's perspective, and that is to impose the conditions that have, I think it's probably a broad agreement with the responsible authorities to deal with this review. I have nothing further to add unless you have any questions.
If I could just add something to what you said, and speaking as a politician and as an elected member who has done the training, what I would like to see from you going forward is a mended relationship, an atmosphere where our officers aren't abused, and that no one does anything that they know is not right.
Yes.
And so when those things are put right, we will have the right relationship going forward to negotiate a licence.
Yes.
And so we all need to go into this negotiation with that attitude in mind.
And I think that is a possible relationship. As I explained earlier, I'm very grateful for the cooperation that has been shown in negotiating the conditions. That hopefully has helped restore some of the relationship that should be there. But you're quite right. Licensing will only work when it is a partnership arrangement. I'm mindful of many years ago when the Licensing Act came into force. I was commissioned to go around the country training licensing authorities and police officers, and I remember talking about partnership in one particular session, and it ended up with the licensing officer from the police and the licensing officers from the local authority throwing bits of paper at each other across the room. That was not partnership approach. That was entirely inappropriate, but we mustn't learn from that lesson. We must learn from the lessons that have occurred in this instance and make sure that actually there is a mutual respect on both sides, and that the pressures that I know occur for local authorities and enforcement officers are recognised, and likewise the pressures for the business as well. Your points are very well made.
any other comments from anyone before we close the meeting? It would be quite nice if we could have a proper apology to our officer for the being abused.
Chair, it is within the papers that you have it written in the statement. So that apology has been given.
Be given orally.
It's been given in writing, which I would say actually counts for all the verbal.
Mr. Are you prepared to offer? Yeah, I apologise wholeheartedly. It was one of those moments which was completely out of context. And the fact that Mr. Hardy brought up drugs, which was really close to my heart, that we don't do and we don't have, and that he was taking photographs of cigarettes, which really riled me up because obviously we don't do that about people that are lost because that was blown out of proportion, and we felt that that was going to be used against us. And I felt that was wrong, so that's why that was said. So I apologise for that wholeheartedly. Hopefully that won't happen again. In fact, if I would just add that it was Shirley and I that came to see you, Kieran, and Mr. Shaver, because we felt that the amendments weren't right. We came to see you, and I think that's what started this whole process, actually. It wasn't the authority coming to us. We felt that this was wrong in the first place. So it was us that came to the authority to get this started.
Well, we are where we are, so
Yeah, sure.
let's say we can go forward and get this sorted out as quickly as we can, so that you can build up your trade. I won't say COVID's gone away, because it certainly hasn't.
No.
But the trade is getting better.
Yes. Chair, is it your intention to rise and make your decision now or deliver that in 5 days?
It's our intention to make the decision now, and you will have a letter from us.
I'm grateful. I'm conscious that things do change
It
from
won't
time
be
to time.
announced today.
It won't be announced today. That's perfect. Thank you.
Thank you. Okay.